Well, the good news about day 18 is it hasn't been as brutal as the previous days have been. Not really as emotionally draining to cover, but it's still not going well for Assange. This is still very much a kangaroo court against him, and Judge Breitzer actually ruled that there's going to be no closing arguments. Well, there are going to be closing arguments, but they'll be submitted in writing without any oral hearing, not even an oral summary. Now, the defense actually accepted this because it gives them time to address the superseding indictment, the one they sprung on them a few weeks before the hearing resumed. So this actually gives the defense another 3 weeks to put together their closing. But as Craig Murray says, this entire hearing has been conducted in effective secrecy, a comprehensive secrecy that gives sharp insight into the politico-economic structures of current Western society. Physical access to the courtroom has been extremely limited, with the public gallery cut to 5 people. Video link access has similarly been extremely limited, with 40 NGOs having their access cut by the judge from day one at the Old Bailey, including Amnesty International, PEN, Reporters Without Borders, and observers from the European Parliament, among many others. The state and corporate media have virtually blacked out this hearing with a truly worrying unanimity, and despite the implications of the case for media freedom. Finally, the corporations that act as internet gatekeepers have heavily suppressed social media posts about Assange and traffic to those few websites which are reporting. Here's a question I have for those of you watching it on YouTube. Did you find this video through a search, or did you see it in related videos? If so, leave a comment and let me know, because I don't think these have been showing up, even in searches that would have been relevant. I mean, it really does seem to be systematic and across the board. But if I'm wrong, there should be people commenting that way, so please prove me wrong. I want to be wrong. But anyway, Murray points out that the closing arguments are the part which the media is most likely to report. They sum up all the evidence heard on both sides and what might be drawn from the evidence. To have these simply submitted on paper without the drama of the courtroom is to ensure that the hearing will continue to be a media non-event. So the defense is going to lodge their closing arguments on the 30th of October, the prosecution will reply on the 13th of November, and the defense will be able to make further response by 20th of November. Breitzer will deliver her judgment in January, and that's notwithstanding whatever the result of the election might be. So now the prosecution has another 2 affidavits, another one from Kronberg dated the 20th of August, so just over a month ago, and one from a prison psychiatrist named Lukefeld or something like that, Lukefeld, dated on the 3rd of September 2020, less than a month ago. And Murray says, it is a very strange feature indeed of these extradition hearings that the defense have no right to cross-examine witnesses who are U.S. federal employees. Gordon Kronberg has submitted 5 separate affidavits containing much which is disputed hotly as to fact, but he cannot be cross-examined, nor may Lukefeld be cross-examined. Fitzgerald, and he's for the defense, remember, made the point that the defense had to respond to this prosecution evidence somehow, as it could not be cross-examined. He stated that, as it had been submitted by the prosecution within the last 4 weeks, it had taken the defense a little time to find expert witnesses who were in a position to contradict and then take their evidence. The defense now had 2 excellent witnesses with personal knowledge of ADX Florence and wished to enter their evidence. The defense accepted that because Breitzer had stated that the trial will end next week, there would not be time to cross-examine these new witnesses, but then the prosecution witnesses couldn't be cross-examined in the first place. Well, James Lewis, you know this guy, he strongly objected, saying that the defense had more than a year to prepare these statements. How? You only gave it to them a few weeks ago. They haven't had a year and you know it. And he accused the defense of just trying to prolong the hearing. What, by wanting to actually rebut all of the crap you've been putting in? Oh, but get this next part. He said that the defense witnesses did not have the authority of the U.S. government witnesses, and they needed to be cross-examined because many of the defense experts were not really expert at all. So if you're with the government, you have authority, and your word is God's holy writ and cannot be cross-examined, cannot be countermanded. Oh, but if you're called by the defense, you can't possibly be an expert in anything, no matter what your credentials are. So after this, and we've seen this before, Judge Bereitzer yet again read out a ruling from her laptop, which had been written before she heard either Lewis or Fitzgerald speak. Entirely predictably, she ruled that the defense statements were not admissible as being too late. The defense had had a fair opportunity to investigate. Defense witnesses must be liable to cross-examination. These proceedings had lasted too long already, and there must be an end to new evidence. As a matter of fairness, a line must be drawn, she intoned. She seemed particularly preoccupied with the notion of fairness, which apparently almost always entails ruling against the defense. So, no closing speeches, and 2 key witnesses not admitted. So, getting to the witnesses, you have Jacob Augustine. His evidence went to the fact that it was not Assange or WikiLeaks who first published the unredacted material, and Augustine added additional information that Assange had actually tried to prevent it. And the other interesting point about his evidence is that it pointed squarely at Daniel Domscheit-Berg, who was a guy who defected from WikiLeaks, saying that he had been responsible for the emergence of the encrypted but unredacted cache on the net. So that evidence, I think, was read in, and Patrick Eller was the only one who was heard in person. And this is based on the accusation that Assange conspired with Chelsea Manning to crack the hash password to help Manning cover his tracks and to obtain documents. And he said, securing Eller was rather a coup for the defense, as there could not be a better expert witness on this particular subject. And so these go to jabber conversations between nobody, who is believed to be Chelsea Manning, and Nathaniel Frank, who is alleged to be Assange. But as we're about to hear, there's no forensic evidence that Nathaniel Frank is Assange, or indeed any single individual. Now, since Murray, by his own admission, is not a tech guy, I'm going to switch over to Kevin Gostola's blog coverage of this. And he mentions that Assange was charged with conspiracy to commit computer intrusion and accused of agreeing to assist PFC Chelsea Manning in cracking a password. So for the password hash, and neither of these 2 guys are really tech guys, but I am. I wasn't in court, but they were. Hopefully we can put it together, and I've also seen the chat records, because on the Bogosity podcast we've been covering this case as it's been going on, and so we covered the chat records when it was released of this Jabber chat. And there are really 2 hashes at stake. One was a password hash that was apparently to log on to the local computer, and the hash was given, and apparently Manning believed it to either be an LM hash or NTLM hash. LM is LAN manager, and that's kind of the old way of doing it in Windows. LM hashes are just really, really, really easy to crack. In TLM, which is kind of the later version, they're a lot more difficult. There are still vulnerabilities up to them, but at least if it's been since Windows 7, those vulnerabilities have been taken care of. So just getting the hash should not mean getting into your computer, but it didn't used to be that way. These hashes used to be a lot easier to crack. However, just getting the hash wouldn't do you any good. You also had to get something called a SAM file, which was the actual file on the computer that contained all of the user accounts and their information. And that's why Eller testifies, at the time it would not have been possible to crack an encrypted password hash such as the one Manning obtained. What Manning sent was insufficient to be able to crack the password in the way that the government has described. Now there was another hash in there that was apparently an MD5 hash. MD5 is an old obsolete hashing algorithm, and at this point, it's pretty easy to crack those. It would have been much more difficult at the time of this conversation, but it was still an old hash that was deprecated, but the entirety of the hash was not put in the chat. It's just a few characters of it, and I think that was just so they could identify and keep track of which hash they were talking about. So there is an MD5 hash involved that was not placed into the chat in its entirety, just a little bit of it, just so they'd know, because apparently these people are talking outside of this Jabber chat as well, and so much of this is just devoid of context and difficult to kind of piece together what's going on. And Gostola writes, the computer charge has morphed over more than 2 years from a specific charge under provisions of the Computer Fraud and Abuse Act into a vague and inexact assortment of general allegations about conduct Assange may or may not have engaged in from 2009 to 2015. But the alleged agreement to crack a password remains in the 2020 indictment announced in June. So, James Lewis comes back up. He's pulling his usual tricks, going back over to Murray for just a minute. Murray talks about Lewis's policy. We've seen this before. Just asking long runs of technical question, trying to get just yes or no answers, trying to get the witness into kind of a rhythm where they'll just answer reflexively and then maybe misleadingly. So he said that Lewis asked long runs of technical questions about the operation of the computer systems, most of which were basic, irrelevant, and both required and got the simple answer of yes. And then, after a run of 12 to 20 yeses, Lewis would throw in a more dubious proposition. This did work once when he got a yes to the prosecution that a great hacker can crack a great cipher. Which is not true, by the way, I'm telling you that right now. By this system of inducing impulsive repetition of yes, Lewis then went on to claim that Assange had once self-described as a fantastic hacker. Look, I don't care who you are. I don't care what you have access to. You can have all the knowledge in the world, and even if you commandeered every single computer on the planet and put it to it, you would not be able to crack a strong enough cipher by the time the universe ended. Nowhere near enough time. No, a great hacker cannot crack a great cipher. Alright, so just going back to Gustola then. Lewis asked Eller if he agreed that Manning and Assange thought they could crack a password and agreed to attempt to crack a password. He told Lewis a hash was provided, and the account the U.S. government associates with Assange said they had rainbow tables for it, but Manning never shared where she obtained the hash. Using rainbow tables is one decryption method for cracking the hash by guessing different password values. No, it isn't. You got that wrong, Gustola. A rainbow table is kind of a shortcut you can take. So you take like all the dictionary words and like the 1,000 most used passwords or whatever. You go ahead and you make hashes of them. You make a table with the password and then the MD5 hash and the SHA-256 hash and whatever other hashes you think you might need. And you've done all of that ahead of time. So that when you're actually given a hash, instead of trying to run anything, you just look it up in that table. And if it's in that table, Bob's your uncle. You don't have to do anything because you already have it. But that won't work if the password is salted. And a salt is just a random number that's combined with the password when it's hashed. And the idea is that every time you change your password, it changes the salt as well. And so you get completely different hash values and the rainbow table won't work. That's what a rainbow table is. So Eller said the government's own expert witness in the court-martial stated that was not enough for them to actually be able to do it. And so he goes into, back on June 12, 2013, David Shaver, special agent for the Army Computer Crimes Investigating Unit, testified the hash value was included in the chat, but not the full hash value, so he must be talking about the MD5 hash there. And Shaver answered, I mentioned the system file. You would need that part as well. This is one of the two files Eller said are necessary for decryption. So that's going back to the LAN manager hash, which I think actually might have been in the chat in its entirety, but it's useless on its own. You need that SAM file. And Hurley asks, and this was the defense attorney, so the hash value included in the chat wouldn't be enough to actually gain any passwords or user information? Shaver replied, correct. Eller was asked multiple times by defense attorney Mark Summers on re-examination whether he saw evidence that linked Assange to the Nathaniel Frank identity, which the government believes is Assange. He said, no, I did not. And Gustola mentions that the government had no clear evidence in 2013 that Assange was the one communicating with Manning through that Jabber username, and they still do not have proof it was Assange in 2020. He also points out that Manning had already downloaded the Reykjavik cable, Guantanamo files, Iraq war logs, and Afghanistan war logs. Routinely in the course of work, she downloaded war log documents to have offline backups in the event of connectivity issues. The only set of documents named in the indictment that Manning sent after the alleged password cracking attempt were the State Department cables, but Manning had authorized access to these documents. So these passwords have nothing to do with what sort of documents Manning could have gotten. And so kind of the assumption everyone's been going on is that, well, yeah, okay, it wasn't about that. It was about trying to get them as a different user to cover Manning's tracks and protect Manning as a source. Well, turns out that assumption might not be great. Eller showed soldiers at Forward Operating Base Hammer in Iraq, where Manning was stationed, were constantly trying to crack administrative passwords to install programs that were not authorized for their computers. So this was just something people were doing. And to Eller, Manning never would have tried to use a password hash to exfiltrate files for submission to WikiLeaks. She had a Linux CD that allowed her to access files on her computer and bypass Windows security features. It is known she used this CD. So she didn't need that. I mean, you can go into Windows and secure everything all you want. Oh, I've secured this user and I've told the computer that no other users are allowed to see my user files and they're all closed off and I've gone on to all the NTFS security features and I've blocked them all off. Well, guess what? All you have to do is boot from a Linux CD, mount that NTFS partition, and Bob's your uncle. You've got every single file on that system. I don't care what the security features are. Windows has no say over that because Windows isn't running. You can get everything. So it makes no sense that she would need the password to get those documents. And it also turns out it makes no sense that she would need that password to cover her tracks. And so Eller wrote in his statement to the court, while she was discussing rainbow tables and password hashes in the Jabber chat, she was also discussing the same topics with her colleagues. This, and the other factors previously highlighted, may indicate that the hash cracking topic was unrelated to leaking documents. How about that for a twist? And Gostola talks about how computer crime charges have always targeted journalism. And he says it is far-fetched to argue the computer charge against Assange was never about journalism. The charge specifically criminalizes Assange for allegedly knowing Manning had made unauthorized disclosures of classified information to WikiLeaks, as if he was supposed to reject documents from a source because she was breaking the law. And he quotes from the charge, at the time, Assange agreed to receive and received from Manning for the purpose of disclosure on WikiLeaks the classified Guantanamo Bay detainee assessment briefs, the U.S. Department of State cables, and the Iraq Rules of Engagement files. Assange knew that Manning was unlawfully taking and disclosing them, and at the time, Assange agreed to assist Manning in cracking the encrypted password hash. Assange knew that Manning was taking and illegally providing WikiLeaks with classified documents and records containing national defense information from classified databases. And Gostola points out, this language is directly from the Espionage Act, not any law against computer crimes or defrauding the U.S. government. And he thinks this is just about smearing Assange as a hacker, which you can do because hacker is such a loaded term. He says the charge has shifted dramatically in the latest indictment. Prosecutors no longer believe they have to prove anything related to Manning to convince Judge Dalek there was a conspiracy to commit a computer intrusion. It seems like payback for embarrassing the U.S. government by unraveling their password-cracking conspiracy theory with their own digital forensic expert's testimony. Assange is accused in the 2020 indictment of conspiring with a hacktivist group known as Lulzec, who were convicted of offenses several years ago. He is accused of making speeches at conferences to recruit system administrators at U.S. intelligence agencies as WikiLeaks sources, like NSA whistleblower Edward Snowden, who WikiLeaks helped leave Hong Kong. But Gostola points out Snowden was never a WikiLeaks source, but it does not matter. And that's true, Snowden was the source for The Guardian and Glenn Greenwald. But Gostola says this charge is a mismatch of anything hacking related that they can fling at Assange with alleged unindicted co-conspirators suddenly included. The judge refused a defense request to remove this conduct from the fresh extradition request, which was served against Assange weeks before the extradition trial. Assange's legal team will have to find a way to address it in their closing argument, even though they have no witness to appropriately deal with the allegations. So that's all the juicy tech details, but we've got one more thing from Judge Dalek. She heard arguments on whether the full medical records of Assange from the doctors and psychiatrists who had given evidence should be released to the media. They have been requested by the press. The records contain a huge amount of background and many intimate details of Julian's childhood and relationships which are in evidence but were not given in open court by the doctors. Both defense and prosecution opposed release, but Bereitzer kept referring to open justice. You will remember that earlier this year, Bereitzer decided that it was in the interests of open justice to release to the media the identity of Julian's partner, Stella Morris, and her children. That, too, was against the wishes of both prosecution and defense. And Murray concludes that a judge so intent on shutting down or refusing to hear defense evidence is suddenly so preoccupied with open justice when it comes to hurting Assange by release of his deeply personal information is a great irony. Bereitzer will rule on this Monday, and I hope humanity has prevailed with her. And I'm recording this on Monday morning, so I can't tease you on what's happened with that. But and this goes back to a couple of things we saw at the start, where both the prosecution and the defense were saying, like, no, we think it should be this way, and Judge Dalek was doing it her own way. I do want to make one more point. They're trying to use the term hacker to smear Assange. There is nothing wrong, per se, with being a hacker. Just like there is nothing wrong, per se, with being a lockpicker. It depends on whose locks you pick. You can pick your own lock if you locked yourself out of your house, or you can have a job as a locksmith. People lock themselves out of their house or their cars. You can get them in. That's a good thing. It's only a bad thing when you use it to break in to property where you don't have permission to be. Same thing with hacking. There are completely ethical forms of hacking that are actually important. But government doesn't like that, just like they don't like strong encryption. So they're going to try to use that to continue their negative smear of hackers across the board and sweep up Julian Assange along with it. So thank you very much for listening. Please, as I said at the start, this is being shadow banned. This is being ignored by the press. Please share this information far and wide as much as you can. And if you appreciate what I've been doing, please go to donate.bogosity.tv. Give what you can. You can become a regular supporter at Patreon and Subscribestar. I've been posting these early for the regular subscribers, so you can get them pretty much as soon as I make them. Or you can give a one-time donation with PayPal, or just a few pennies with crypto. That's a nice thing about cryptocurrency, like with Dash. The transaction fees are so tiny. If you just want to send me 5 cents or something like that, I'll take it. Every little bit helps. It's probably more than I'll get from monetization, but I think this is really important. So thank you so much. Until next time, stay strong and be free.